Yo, what it is, people, we is back. Never down, keep it G News. And then we taking a break, stepping out of Baltimore for a minute, and we going to ride down 95 and we going to step into Atlanta. You know, we got to deal with this YSL trial. Haven't spoken on it in a minute, you know, because I don't really like just doing pointless videos, you feel me? Ain't no real new information come out. But, you know, we getting closer to trial. Trial date is actually scheduled for November 27th. I actually thought they was never going to pick a jury. I have never in my life seen a situation where it took, what's this? The trial started in November. They just picked the jury in October. It took 10 months for them to see the jury. That just lets you know what this, the state of Atlanta is dealing with, man. You know, I don't think they actually never had the money to take. I think at the beginning of it was 22 defendants to trial. That was never going to happen. Another guy just copped out yesterday. I think his name is Bree or B or something like that. He copped out to 5 years jail time, 15 years suspended sentence. Then he got to come home, 10 years probation. For most people outside of Atlanta, I know at least coming from Baltimore, Maryland, I ain't never in my life seen nobody cop out to 15 years, man. In my city, we struggle with copping out to 5 years probation. Straight up. But today, well, yesterday, they was back in court. And the judge is getting sick and tired of the state of Georgia playing games.
Sir, I'm going to exclude it. I'm going to tell you that right now. If it has not been served in 1 through 12 already, I'm going to exclude it.
Well, we would ask for the court to hear us out and hear our argument on, because we have briefed this issue and we filed a brief as it relates to exclusion of evidence, Your Honor. So we would ask for you to wait until November 16th till we have our argument, because we have briefed the issue and we would like to be heard.
Hearing it right now.
At some point in time,
Your Honor.
at some point in time, I have to draw a line, and the state's got to be ready with all this stuff. It's just an issue of fairness as well.
Your Honor, and I believe that
I'm telling you right now, Ms. Hilton, if you haven't disclosed it already, between 1 and 12, and it's not exculpatory, it's gone.
Your Honor, we would ask, because we would ask that all of this be reserved for the 16th, because this all came up in September. You said you allowed us to.
I am really annoyed about this, Ms. Hilton. I just am. This is ridiculous. Your witness list has grown by 2/3 since then. And I don't know why. You better have a dang good explanation on the 16th, because if you don't, I'm going to exclude it. Okay. But right now, I'm telling you, without anything further, it's gone.
Well, we would like to
exclude a lot more on that date, because this is ridiculous. There is no plausible explanation I've gotten and that would suffice, that we just kind of keep, well, you keep dripping and driving out evidence.
Well, we'll be asked to be heard on the 16th, Your Honor, and we'll have all the explanations for the court. I'm
telling you, it better be a good explanation, and if it's not, I'm going to exclude it. I'm just going to tell you that right now, because you all have also dragged the court along in terms of, I've asked Ms. Hilton, not Ms. Hilton, I've asked Ms. Love several times to tell me why it is that it's taken so long. And the explanation I get is, we have duplicates, okay? I don't doubt that there's probably some duplicates, but I still have an issue with why your witness list has grown, almost doubled. I just do. And can you explain that to me at this point in time, Ms. Hilton?
Your Honor, the state's witness list has not grown. All of the witnesses that are on the compiled list are in the discovery. And we have case law to say so long as that they're in the discovery, the state does not have to provide a consolidated witness list. Every witness was in discovery in a police report or in some other type of report. So the idea that we provided a whole bunch of new names is just not true. And so we will further explain this with the relevant case law on the 16th. All of this is inside of our motion that we have filed. But this notion that we provided new witnesses, that is not the case.
That is the case.
Okay, well, listen. If you haven't disclosed this, and I'm telling you right now, in 1 through 12 already, it's not otherwise in there, but any documents that you've already supposedly given in discovery, I'm going to exclude it. I'm going to exclude it. If it's a duplicate and you can show the court and counsel here that, yeah, we gave that to you in discovery dump 3 and it was in there, then that's, I don't have any issue with that. Because I do agree that as an advocate, you do need to search your own discovery and whatever. I get that. But if this is the first time it's coming out,
we would ask that you hold ruling, Your Honor, until the 16th so we can have a proper hearing, Your Honor.
I object to that. You've ruled.
Your Honor, that's the date that you set it for us, because that is the date that the court set it for us to give us an opportunity to be heard, and we are asking that we can be heard on the date that you set for the motion.
Well, I haven't heard anything at this point in time. Did you disclose Officer Baker's report in discovery dumps 1 through 12?
I need to check that, Your Honor. That is what I'm saying, that we've provided to defense counsel a list of all the duplicates that we have provided, that we've served. So I need to confirm whether or not that is a part of the list of duplicates we have given to defense counsel for both discovery 12 and discovery 13 an audit to let them know what has previously been served. So I need to, at this point, I do not have the discovery audit in front of me, but I will need to confirm whether or not that has occurred.
Okay, all right. All right.
I think that's one of the worst things you can do as a prosecutor or as a defense attorney is tick the judge off right before a trial, you know, because they are human. You know, they're not supposed to come into this thing with no biases, but they human. It happens sometimes, you know, might not even be intentional, you know, but a lot of times the judge still side with the state regardless. But it looked like to me in this situation, in this case, the judge is getting sick and tired of the state of Georgia and the games that they playing. Every other weekend or week, you know, every 3 weeks, they bringing in new evidence. It's like, yo, how do y'all got new evidence, new witnesses, and these guys been locked up for what? They're in there 2 years now. Like, it don't make sense. That's why I don't believe their case is that strong, because if it was, you wouldn't have, you would already, your case would be rock solid. You know, your case would be rock solid. You wouldn't have to keep bringing up new witnesses and new pieces of evidence. And it's like, where y'all getting this from? That's a valid question. Where are they getting evidence from now? But if you heard the prosecutor, she's saying that a lot of these things was doubles. It might not be a new witness. But she want to make sure she cross all her T's and dot all her I's. So what y'all think the judge did? You know, because, like I say, the judge normally side with the state. You can see he was very angry in this situation. And I know y'all probably wondering, what was it about?
I mean,
I'm asking.
Exclude Officer Baker's testimony?
I don't know who Officer Baker is, because Officer Baker has nothing to do with, okay, because that's a different motion in limine. Officer Baker has nothing to do with this. This is Lauren Crabtree and, really just investigator Lauren Crabtree. He's the one who's did the search warrant, and he would be the one to get the return. We'll still look for, I don't know what the court's ruling is going to be now, but we will still look for it. If we find it, we will surely turn it over. But we have definitely endeavored to look and to seek this out. We've gone to, at one point, we've gone to the clerk's office to see if it's at the clerk's office. We don't know where it has gone at this moment, but we will endeavor to look for it.
All right.
And if found, turn it over. But at this point, it's not in the state's possession right now.
All right. Mr. Steele, what you asking? What are you asking for the court as remedy?
To get me to order the exculpatory information to be provided to Mr. Williams as required by Brady et al., and order that the prosecution's late discovery, they had this for years. I got this
Okay.
in
Bottom
September.
line up front. What do you want?
I want this is why I'm in such a bad shape. I thought I was ready for trial, and I keep getting this discovery. I want all discovery from from Discovery 12 to 13 to be
They're saying they don't have it. That's what they're saying. So what's the remedy for me? What are you asking me to do?
Well, let me ask you this.
No.
I understand.
No.
I'm
Answer
answering your
my question. What are you asking me to do?
I'm totally answering your question. But let me show you this. I didn't know about this till September 29, 2023. I'd like you to consider, why didn't I get this when discovery was due 10 days prior to January 4th of 2023? And that is really my basis, because then I would have had a year to understand what to do, and I could have made my own inquiry. At this point, I'm asking you to just do a bright line rule. There is no discovery that the state can use and no witnesses after Discovery 12 and in September of 2023. And that is how you even the playing field. That is what I'm asking. But I'm also not relinquishing the state's duty to supply exculpatory
So
evidence.
if they come up with it,
Be great.
you grant.
It's
So you're asking
exculpatory.
me to exclude Baker's testimony
That's
as well as Crabtree's?
That's a different motion. Officer Baker's a different motion. This is dealing with Officer Crabtree and there's another officer. Let me just get the name. Officer Walsh, Investigator Walsh, W-A-L-S-H. Those are the two on it. But I'm going to call them. This is good for Mr. Williams. So, yes, the state is barred. I'm going to call them, and I would like all the information because it's exculpatory. Now, I'm not saying that there's any other person here who doesn't have their phones looked at geolocation data, and it's helpful for them. I didn't find it in discovery. But, you know, the state is losing evidence.
I still don't understand what you want me to do with
I want you to exclude all discovery produced in Discovery 12 and Discovery 13. It's a late production, including the witness list on September 8th and September 26th of 2023. These are late.
I'm not doing it yet. I'm not doing it
understand.
because I had an argument on it. Do you want me to defer 27 until I hear that
No,
particular motion?
27, I would like you to grant. The state can't use it, but they have a duty to look really hard.
They can't use what?
They can't use any evidence. They can't mention it in open. They can't put up a witness to talk about geolocation data.
That was taken from what, May 7th of 2015?
Right. It's January 10th of 2015.
It looks like this. Okay, hold on.
I think the motion is not 27. I'm not sure if it's the right one. So if you're looking at motion limit 27, it's not the right one.
Let me look and see if that's.
Yes, it is. Paragraph 3, the judge is right. It's motion for discovery number 27 filed on 10/18/23, which is about 2 weeks.
10/20. I got 10/20.
No, it should be 10/18/2023.
I don't have the right one then.
You're right. I thought we were doing motions in limine 27.
Yeah, I have
So
motion
if we're talking about motion to discovery or motion in
I
limine.
have motion limiting, Mr. Steve.
I'm looking at motion for discovery number 27.
I don't have that one. That's not.
Motion in limiting number 27 deals with, as you kept saying, and I apologize, I didn't realize what you're reading from, Officer Baker's report. And that goes back to the May 7, 2015. That's going to be the arrest of QZ. And this goes back to 2015. I got this on September 29, 2023 as well. And I don't know who this witness is. He doesn't come up on a witness list until September 8th of 2023. I mean, it's just the same. I'm in like, you know, I'm like the, on a treadmill. But I was looking at the geolocation data, which is motion for discovery number 27 and motion for discovery number.
I'm gonna take up the discovery motions on the 16th. So not timely quite yet. But what about motion number 27? Okay. So what?
This one.
Motion to eliminate.
Yeah, it's similar. It's similar, Your Honor. It's what you've been saying. So I get this information in Discovery 13. It's September 29, 2023. That's the first time I ever hear about an Officer Gary Baker, which is B-A-K-E-R, and a report is revealed. That report dates back, Your Honor, to, I believe, 8 years before. It's May 7th of 2015. I believe that's about 8
Yes,
years
I have
before.
that. Yes.
And then I just get it, and I don't have much else except this report and the person's name. It's not like I could look in Discovery. It never comes up before, and the name comes on a witness list September 8th of 2023 for the first time. And this is what I'm dealing with. So I'm supposed to go out and interview the person. I don't even know what we're talking about, and I don't know why I'm getting it on a report from May 7th of 2015 today. I mean, not today, September 29th.
Okay, so
I want to exclude it. I don't want to deal with the, I'm trying to make this more manageable for everybody. I just don't, unless it's exculpatory, why am I running down Gary Baker's report now?
okay, what's the state's position on motion to eliminate number 27?
Your Honor, we are asking to address any of the discovery issues on November 16th. I will say that Officer Gary Baker is a witness that has already been identified, as he is the person who arrested Mr. Stillwell on the 17th of on March 17th, 2022. But as it relates to the 2015 police report, we are asking that we can hear all of this on November 16th, because we do know that there were some 2015 reports served in Discovery 13 that has previously been served, and I want to make sure that this report is not included in that group of reports that had already been previously served. And the state did an audit, because in Discovery 12, as well as Discovery 13, there were a lot of duplicates that had already been served. And so what I need to do is confirm that this May 7th report is not a part of those items that had previously been served up to June of 2022. So we will know that answer definitely by November 16th. So we are asking to hear this on November 16th so that we can, one, confirm that this report wasn't already previously served. And yes, and just to confirm that, Your Honor.
And let's assume it was not previously served.
So you see, it's a lot of discrepancies, especially with Brian Steele. You know, he objecting to a lot of these witnesses because he's saying it's been sprung on them. They had a specific date to turn over these witnesses, or these, I guess, witnesses, you know, expert witnesses, eyewitnesses, they all the same. But they had a certain time to do it, and they didn't do it. So it looked like to me, and this is my opinion, like the state is trying to put the defense at a disadvantage. Because the reason why they give these people grace periods and to hand all their evidence in is because the defense has to prepare for all of this. You know, you can't spring something in on them last minute. That's why you heard Judge Glanville say, look, man, if you keep playing these games, I'm not going to allow it in. If y'all don't have a good explanation on the 16th as to why y'all just bringing me this evidence, I'm not letting it in. And in my opinion, still, you talking about on the 16th, that's the last day they can bring evidence into the case. The trial start the 27th, so still, you're only giving the defense 11 days to prepare. But do y'all think the judge allowed this to go on? Or do you think he said, man, look, I'm tired of playing y'all games and no more witnesses? Check out what he said.
I'm gonna wait until that time, but in terms of 27, and you also, I think, made the same argument for 28. Is that correct on this Officer Brian?
Yes, sir.
All right.
29.
29.
Yes, sir. 30.
30.
Yes, sir. There's more.
It's 31 as well.
I'm checking 31, Your Honor.
32 is another one.
This is all as I was going through 13.
So even with all that back and forth and the obvious frustration that the judge displayed, of course, y'all told y'all how this go. It seemed like to me the judge always side with the state. So he still allowed the state to get a few more days to get this evidence through. He just told them they better have a good excuse, which probably not going to be a good excuse anyway. You feel me? Now Brian is still objecting. You know, a lot of times they do that just in case Young Thug get found guilty and then they can go back in on the appeal. So that's how the court system normally works. You feel me? Everybody got a job to do. And look like to me, Brian still is doing his job well. The state look like they fumbling the ball. I don't think the case is strong, man. You know? Anytime they gave out all these deals. And if y'all watched the video I did on YSL months ago, I looked into Georgia. You know, because most people, like I said, outside of Georgia didn't understand that you can get 15 years probation. At least not in Maryland. Straight up. And Georgia is the home of the probation plea. That's what they give you, you know. Even though most of them guys is going right back. Now, so far with YSL, I think either one or two of them already violated. At least one violated already. But for the next 3 years, we're going to see more. I would never cop out to no 15-year probation plea. Never. I wouldn't recommend that to nobody. Not unless you're going to completely change your life and follow Christ. You feel me? Because it's so easy to slip and fall and stumble. Now, I still want to see how this case pan out. You know, at least for Young Thug, man. He's the only one that they after. They are attacking Young Thug aggressively. For what reason? I don't know. You know, they try to blame high crime on YSL. But I got to question the people in Atlanta. Since YSL been off the streets, or since YSL been disrupted or disbanded, how is crime? You know, I hate when they try to make that a thing. You know, this particular gang is causing all the crime in the community, and once we get them out the way, crime going to cease. That's never the truth. That's never the truth, yo, when you got environments that breeds criminals. And I'm sure some environments in Atlanta currently that's breeding criminals. You take YSL off the streets, it's going to be another gang coming up just as strong as YSL, if not stronger. Might not have the financial backing, but they might be ruthless. But trial is scheduled for November 27th. It's all going to play out. It's all going to be public. You know, it's probably going to be some more plea deals by the time trial started on the 27th. I'm sure some more people going to cop out. Like I said, a guy copped out yesterday. Ultimately, they might only take 5 of them to trial. You know? And a lot of them guys are going to have to testify. Guys see what Gunna going to do. You know? His lawyer don't seem to think he told. I beg to differ. You know? I told y'all a million times, yo, when you got these situations where you got multiple co-defendants, everybody got to go to court. You know? If we taking deals, we taking deals. But you got to make sure the deal is universal for everybody. You know, we all copping out because you don't want to leave nobody on the island. Like YSL did Thug. But we'll see how it all play out. Make sure y'all subscribe to the channel. Support Keep It G News. And I'm out.
Nigga can't do what I do. Y'all niggas can't copy me. Let's keep shit G. Let's keep shit G. Let's keep the shit G. Let's keep shit G. Let's keep shit G.